Welcome to Carbon Connection, the podcast bringing you the latest insights from the front lines of climate action. I'm Lauren Napuck with the Climate Action Reserve, and together we'll hear from industry leaders driving real progress against climate change and explore the ever-evolving world of carbon markets and climate policy. Thanks for joining, and let's get started. Hi, everyone, and thanks for joining this week's episode of Carbon Connection. Recently, we've seen significant shifts in U.S. government perspectives, particularly within the U.S. Supreme Court's approach to environmental policies and regulations. One of the latest decisions by the court was the overturning of Chevron deference, marking a pivotal change in administrative law. This ruling, along with others, highlights a broader trend of skepticism toward agency authority and increased scrutiny of environmental regulations. Today, we're diving deeper into this topic with the esteemed Ann Carlson, the Shirley Shapiro Professor of Environmental Law and co-director of the Emmett Institute on Climate Change and the Environment at UCLA. Ann is a leading scholar of climate change and air pollution law and policy. From 2021 to 2024, she served in the Biden-Harris administration as chief counsel and acting administrator of the National Highway Traffic Safety Administration, where she led the development of strong fuel economy standards to cut greenhouse gases from cars and issued numerous vehicle safety standards. Ann is also an elected member of the American Academy of Arts and Sciences and a fellow of the American College of Environmental Lawyers. I'm thrilled to speak with Ann about the role of the Supreme Court in ensuring effective regulation, strategies for navigating this evolving legal landscape, and what these shifts mean for the future of environmental governance in the United States. Ann, thanks so much for joining me.
Sure, it's great to be here. Thanks for having me.
Absolutely. The pleasure is all ours. And to start, Ann, as we know, there's lots happening right now in the environmental policy field within the U.S., but I'm hoping you can kick us off by explaining first what Chevron deference is and why it has been such an important legal doctrine for federal agencies.
Sure, the Chevron deference standard is something that courts have used for 30 plus years to review agency interpretations of statutes that are either unclear or have gaps in them. So Congress passes a law, it delegates authority to an agency to issue regulations to implement the statute. And sometimes the statute's less than clear about what exactly the agency is supposed to do. So the agency has to supply an interpretation of what the law requires. And for many, many years, under a case called Chevron, the Supreme Court directed lower courts to defer to an agency's interpretation of a statute that was ambiguous or where there was a gap left open, as long as the agency's interpretation was reasonable.
Thank you so much, Ann. That's really helpful for us to kick off the importance of deferring to agencies when we have this ambiguity. And of course, Chevron deference can apply across the board, but I'm wondering if you can share how has Chevron deference historically influenced environmental and climate regulations specifically in the U.S., and why is its overturning so significant?
The Environmental Protection Agency issues more regulations than any other federal agency. And so that means that it is in the business frequently of interpreting statutes that are ambiguous. And it has a lot of expertise in the statutes that it administers. So that includes the Clean Air Act, the Clean Water Act, various statutes that cover toxic chemicals, the disposal of toxins on land, the transport of hazardous materials, all sorts of statutory obligations. And one of the reasons that Chevron deference has been so important is that the agency has a lot of expertise in how it implements those statutes. And that was really the basis of Chevron deference. We have experts in the agencies. They've worked with the statutes for many years, and we should defer to their interpretation again, as long as that interpretation is reasonable. However, the Supreme Court, starting probably a decade ago, began to cast doubt on whether courts should defer to agency interpretations of the law. And it became pretty clear that Chevron deference was going to disappear. And the question really was going to be, when would it disappear and what case would be used to overturn Chevron? That happened this term in a case called Loper Bright versus Raimondo.
Thank you so much, Anne. That's so interesting that we were wondering when this might possibly happen. And now that we've seen it happen, we're looking forward to see what is next in terms of how agencies are going to be able to provide this expertise and how would we be able to defer to them. So, in conjunction and beyond the overturning of Chevron, how does this decision fit into a broader pattern of Supreme Court rulings? And what does it reveal about the court's stance on agency authority?
I think it's fair to say that this Supreme Court, which is made up of 6 conservative justices and 3 liberal justices, is pretty hostile to agency action, particularly when that action is ambitious. And so we've seen at least 3 cases that are really important in the administrative space over the past year, and then another trend that is really important, particularly for environmental regulation. So Loper Bright versus Raimundo is one that, again, is the case that overturned Chevron deference to agencies. Another case called Security Exchange Commission versus JARCSI, super technical, but in that case, the court said that agencies that use administrative law judges to hear enforcement cases can't do that anymore. There's some nuance about which agencies it's going to apply to, but those cases will have to be heard in federal court instead of by agencies, which is more expensive, more cumbersome, and is likely to slow down enforcement. And then the final one is a case called Corner Post versus Board of Governors of the Federal Reserve. You'll note that all of these cases involve agencies other than environmental agencies. And in that case, the court essentially said that if a party wasn't previously subject to a regulation, it could challenge a rule or regulation anytime. Previously, there was a 6-year statute of limitations, so we had some certainty once a rule had been on the books for a while. This case basically says, well, if you weren't regulated before and you're now regulated, you can actually challenge an old rule. All of this is designed to make it easier to attack agency action. But then there's an even bigger trend. And again, this is across agencies, but the Environmental Protection Agency might be most affected by this trend. And that is the court using something called the major questions doctrine. This is a doctrine that was actually used to strike down vaccine mandates for employers. It was also used to strike down some of the forgiveness of student loan debt. And very importantly, it was used to strike down the Environmental Protection Agency's Clean Power Plan, which was the rule the Obama administration issued to cut greenhouse gas emissions from the electricity sector. And the basic idea of the major questions doctrine is, if an agency is going to regulate in an area that works a large transformation in the economy on a so-called major question, it needs very direct delegation from Congress. If Congress hasn't spoken directly to the issue, then the regulation is invalid. It's simply struck down. And so with respect to the Clean Power Plan, the Clean Air Act directs the Environmental Protection Agency to cut pollutants from a bunch of different sources: cars, trucks, stationary sources like power plants, chemical plants, et cetera. But it doesn't specifically delineate all the pollutants that the agency is supposed to regulate. And in Massachusetts versus EPA in 2007, the court said greenhouse gases are pollutants under the Clean Air Act. And so the Clean Power Plan was issued because greenhouse gases come from power plants, and EPA was doing its job under the Clean Air Act. But the court said, Congress hasn't really said anything about greenhouse gases in the Clean Air Act, and you went too far. This was a rule that was too ambitious. It was going to work a transformation in how electricity was produced, and we are going to strike that down because, again, Congress hasn't spoken directly to the issue.
Thank you so much for providing that context, Anne. It's really helpful for us to not only understand how the Supreme Court is striking down these environmental regulations, but providing this example of the Clean Power Plan and what this looks like in terms of the Clean Air Act and how we're going to take a look at emissions now from these major polluters. So it's really helpful to understand these cases. And alongside that, I'm wondering if you can share what this trend of striking down environmental regulation says about the court's approach to environmental law.
Sure. I've already noted that this is a Supreme Court that seems pretty ambivalent at best about ambitious agency actions across enforcement, across rulemaking, and so forth. But we've also seen the court strike down a number of environmental regulations specifically, and they've used different doctrines to do it. This is not just Chevron, it's not just the major question doctrine. It just seems to be an overall hostility to environmental regulation. So I've already talked about the Clean Power Plan. That was a big loss for the Environmental Protection Agency. The court also struck down something that's known as the Waters of the United States rule. WOTUS is the abbreviation or the acronym in a case called Sackett versus EPA. And that was a rule that protected a lot of wetlands, which are really, really important environmentally. They're really important for things like flood control, for aquatic life. Something like 40% of all freshwater species are dependent upon wetlands. They provide protection against coastal erosion. And we've been decimating our wetlands over the course of the last 50 years or so. So there's been a new policy to really try to protect wetlands. The WOTUS rule defined wetlands pretty expansively, and the court struck that down. And then very recently, in a court case called Ohio versus EPA, the court put on hold a rule that is designed to address cross-state air pollution. So this rule is called the Good Neighbor Rule. And one of the things that we see with air pollution is that power plants in the Midwest and the Southeast emit pollutants that actually then get transported into other areas of the country, most predominantly the Northeast. And so this was a rule that was designed to try to limit that cross-state air pollution. And the court said it can't go into effect because we think the states that are suing are going to win. Interestingly, in that case, Justice Amy Coney Barrett issued a very strong dissent. So that's just an interesting trend to watch. But those three together, the Clean Power Plan, the WOTUS rule, and the Good Neighbor rule, are really important environmental policies. And they have all now been basically put on the chopping block by the Supreme Court.
That is, even hearing you walk us through these cases as an environmental advocate, but as a US citizen, it's a stark time. And it's upsetting to hear these things that are here to serve and protect things, not only like wetlands and our ability to provide flood control, as you mentioned, with WOTUS, but with the Clean Power Plan and being able to protect the health of people and providing clean air. It's definitely challenging to see these things and protections set up to help us be taken away and have agencies be attacked as well as a result of this. So I appreciate you sharing these examples with us, Anne. And I'm wondering, additionally, how will this ruling and broader trends affect agencies like the EPA, particularly in their ability to regulate greenhouse gas emissions and address these other climate-related challenges that we're seeing?
So I would have an answer that is different for you had the election gone in a different direction, because President Biden issued a number of very ambitious climate rules that address things like, again, electricity emissions, greenhouse gas emissions from the electricity sector, greenhouse gas emissions from cars and trucks, regulating methane pollution. Methane is a very potent greenhouse gas. The new president, President-elect Trump, has made clear that he's going to roll back all these rules. So I suspect that the Supreme Court won't actually hear challenges to them, although we may have one challenge that's currently pending in the DC Circuit Court of Appeal against fuel economy and greenhouse gas emissions rules for model years 2023 to 2026. So it may be that the Trump administration actually can't roll those back in time, and the challenge will go forward. If those are upheld by the DC Circuit, you could see the Supreme Court taking them up. Particularly the EPA greenhouse gas rules could be challenged, and the basic argument by the opponents of the standards is that the major questions doctrine prevents EPA from pushing the electrification of the vehicle fleet. Although the rules don't directly mandate zero-emission vehicles or electric vehicles, they are ambitious. They're an attempt to really cut greenhouse gases from the vehicle fleet, and the best way to do that is with electric vehicles. There's one other area that I am quite concerned about and pending right now in front of the United States Supreme Court, And that has to do with California's regulatory authority under the Clean Air Act. So California has a special role to play under the Clean Air Act, and it has since the 1960s when it first began to regulate automobiles that were causing terrible smog in Los Angeles. Congress singled out California and said, California, you can issue standards for pollution that are different from the federal government's as long as they are more stringent than federal law, because you have compelling and extraordinary circumstances. California has used that authority to really push its vehicle fleet to zero emissions. And right now, pending in front of the United States Supreme Court is a petition to review a rule called the Advanced Clean Cars Rule, which accelerates the introduction of zero emission vehicles, primarily electric vehicles, though it's not limited to electric vehicles. We don't know if the court's going to take that case. The Trump administration will undoubtedly roll back California's permission to issue those standards and a number of other standards that the state has drafted and developed to attack greenhouse gas pollution. So that's another place where I think we're going to probably see court action. We will certainly see the new president come in and dismantle a lot of these rules.
Thank you, Anne. I appreciate you sharing that. And of course, just have to say it is so timely us having this conversation post-election and being able to review not only the impact of rules being rolled back, but how this will also impact state level action. And we've given nod to various sectors, but now we're also looking at transportation. And it seems that all aspects of the environment and climate policy is hindering on this level of action and rules being rolled back. So thank you for sharing that. And looking at the Supreme Court's impact and taking that step aside, what role does Congress need to play moving forward to ensure effective climate regulation, given the court's limitations on agency authority?
So again, that depends on the makeup of Congress. But the one bright light that I want to focus on is the Inflation Reduction Act. So Congress passed that act in 2022, and it is the biggest piece of federal climate legislation ever enacted. Rather than regulating, it provides lots of money through tax incentives, grants, and loans to basically every sector of the economy to try to spur reductions in greenhouse gases through investments in green technology, through incentivizing innovation in green technology, and so forth. It's really important. It is being taken advantage of by battery manufacturers, by wind and solar developers, by consumers who are purchasing electric vehicles with tax credits, and more. There's a lot in that legislation. Trump has said that he wants to repeal the Inflation Reduction Act, but that's a pretty unpopular move, and it requires, of course, a vote of Congress. We know that a number of Republicans are actually pretty happy with a lot of the provisions of the Inflation Reduction Act because money is being channeled into their districts. Jobs are being created in their districts, and that's pretty politically popular. So 18 Republicans have written a letter to Speaker Johnson saying, don't repeal a number of the incentives in the Inflation Reduction Act. If that all stays in place, then we're going to really continue to make a lot of progress in reducing our greenhouse gases, not as much as we would make had the election gone another way. California and other states are also going to enact their own policies to try to really continue the green revolution, to continue cutting greenhouse gases. The new administration makes that tougher. But if the IRA stays in place, and I suspect that most of it will, though probably not all of it, then we really are on our way to transforming the electricity sector with huge growth in renewable resources and the transportation sector where consumers now have 117 models they can choose from in buying an electric vehicle, leasing an electric vehicle. That is completely different than the landscape even 5 years ago.
Definitely. And I appreciate you giving this nod to the IRAs. It's for sure a breath of fresh air, I think, of having such bipartisan support to be able to create jobs, support this green transition within the US, and funnel grants and incentives into states so that they can be implementing the IRA is hopeful for the future, at least within that regard. And looking at the IRA, but outside of the IRA as well, what strategies should businesses, policymakers, and your everyday advocate adopt to navigate this shifting legal and regulatory landscape while also continuing to make progress on climate goals?
So I think there are really two places to focus. One is really letting Congress know that people care about climate change and that the Inflation Reduction Act should not be repealed. Now, it's going to be some months before the new Congress convenes. Of course, Trump doesn't take office until January 20th. But once that starts, I think citizen activism, citizen voices are really, really important. Climate change can be hard to get people to get stirred up about because it can feel abstract until you get hit with a hurricane or flooding or heat waves. But it's really, really important that people make their voices known. I think businesses that are affected by IRA will do that. I have a lot of confidence that the interests that are getting tax incentives, grants, et cetera, are going to make their voices known. But it's just really important that that not be confined, I think, to the regulated party or to the parties rather that are actually benefiting from those tax incentives. Then, depending on where you live, states can do a lot to advance greenhouse gas emissions policies. A number of states already have policies to commit their economies to zero emissions, typically by about mid century. There's a lot they can do to, for example, procure zero emission vehicles for government fleets. They can enact renewable portfolio standards that require utilities to get green energy to provide on the grid for utilities. They can provide incentives for homeowners and renters and landlords to make buildings more efficient, to convert to green power, to put solar panels on roofs. There's lots of activities that states can engage in. And so, as occurred in 2017 during the first Trump administration, a lot of states really stepped up. And we're going to need to see that again to continue the progress that the economy is making in cutting greenhouse gases, particularly from the electricity sector. Really got to work on the transportation sector. That's been a harder nut to crack. But with the huge influx of electric vehicles and investments by auto manufacturers in green technology, I think we're really starting to turn a corner there too.
Absolutely. Yes. Thank you so much, Anne. You've really provided us hope in being able to see a path forward. And even as we enter this new administration and have changes in Congress and seeing these changes on the Supreme Court level, you as a citizen have the ability to let your Congress and let your legislators know what you care about and standing up for climate action. But on the flip side, you also, as a state, being able to support these incentives and bringing that back to the citizens of your state as well and supporting green action through these things you've mentioned, like energy efficiency and building efficiency and transportation. So hope is not all lost, and we need
Right.
people's voices to step up for action to happen and to ensure everyone knows that we care about this critical issue of climate change. And we've walked through a lot of these different cases and the impacts that they're going to be having. And I'm wondering, forward looking, what upcoming Supreme Court cases should we be watching for? And what might their outcomes mean for future climate legislation and regulatory frameworks?
Sure. So, one case that's pending in front of the United States Supreme Court has to do with the National Environmental Policy Act and how climate change is considered in evaluating the environmental impacts of government action. I'm going to just hazard a wild guess that that is not going to be a good outcome. NEPA has actually not fared well in the Supreme Court over many years, not just with this court. So there's that case. And then, as I mentioned, California's ability to get permission from the Environmental Protection Agency to issue its advanced clean car rules is pending right now. There's a petition pending in the Supreme Court. We're still waiting to see whether the court will grant that. And then it's hard to say what happens next. A lot of it will turn on what happens with the Trump administration. I will say that environmental lawyers and states were very successful in challenging a number of the rollbacks that the Trump administration issued during the first term. Something like 83% of court cases succeeded. That's often because the rollbacks were done in a very sloppy and haphazard way. I will say that the current appointments that we're hearing about to various cabinet level positions suggest that we may see more of that sloppiness, more of that inattention to actually how government functions So you can stay tuned to watch a lot of court activity. California and other states will be at the forefront, I think, of challenging policies that appear not to comply with the law, that are anti-environmental, that don't apply or don't follow process. That was something that the first Trump administration seemed to have a lot of difficulty in doing. So the courts will remain very active here. And we often lament that the courts have turned in a particular ideological direction, but President Biden has nominated a huge number of judges to both the district court and the courts of appeal. They still have a lot of influence, a lot of power. Not everything goes to Supreme Court. In fact, most cases don't go to Supreme Court. So we are likely to see a lot of action, and some of that will definitely succeed. One that we didn't talk about because it's not really involved, the courts aren't really involved, but that President Trump has threatened to withdraw the United States from the Paris Agreement, which is, of course, the agreement that 180 some odd countries have committed to and committed to reduce their own greenhouse gases. I think that's just a huge mistake, not just for climate policy, but really internationally. Basically, what the United States is doing is saying, we're going to let China lead here. And China is advancing green technology very rapidly. 60% of their new car sales are electric vehicles. They have a lot of new models that are actually quite affordable and good quality. So it's a very odd choice to make from a global perspective, just worth emphasizing.
Absolutely. Yes. Thank you, Anne, for giving us this forward looking watch with NEPA and other different cases coming forward for the Supreme Court. And although we are facing lots of challenges, hopefully we can be successful as well as climate advocates. And before we close today, Anne, I also just want to allow you the space to give any advice for any of our audience members listening or any parting thoughts that you'd like to share, as I know that this is a tough issue that both of us are tackling today in this episode.
The other thing I would say is just to repeat something I said earlier. We get a lot more done if people express their voices. And that can sometimes be frustrating, but Congress needs to know that people care about climate. It wasn't front and center in the election. I'm sorry about that. I think it might have motivated some younger voters to come out. The youth movement, the Sunrise Movement, has been really actually very influential in getting the Biden administration, for example, to take a whole government approach to reducing greenhouse gases and to really think about it on an economy-wide basis. Voices matter. They make a difference. And so express your voice and do it in individual letters. Don't do it by form letters. That is much less effective. You can also comment on rulemakings, and it's not hard to do. You can just go online and figure out how agencies solicit comments. They're required to by law when they change rules and regulations. And the agency is required to read and respond to every one of those comments. So if you see a rulemaking coming out that is really negative, express yourself about why it's a bad idea. You can do it orally in a hearing. Those are often on Zoom, or you can do it in writing. And agencies pay attention to them. So I would also encourage you to think about administrative agencies as a place where you can express your support or your opposition to a particular policy.
Absolutely. Thank you so much, Anne, for sharing that and providing us these tools to take away and uplifting voices and ensuring that we know that our voices matter and we have these places to go to express our opinions and champion the climate as the telling issue of our time. So I really just want to thank you so much for your time and expertise today. And it's been such a pleasure covering this topic with you.
Great. Great to be here. And don't give up. That's the most
Yes,
important message. We got to fight back.
absolutely. Yes, don't give up. Thanks, Anne.